Hello. Today we are going to speak about affidavits. Affidavits are written statements that you swear are true and can be used as evidence in court. In the US, in particular, documents filed by lawyers are often required to be sworn. The opening paragraph of these affidavits are as follows. I, Robin Bernstein, do solemnly swear under the penalties of perjury that the following facts are true to the best of my knowledge and belief. The person making the affidavits is often called the affiant, and at the end of these affidavits there is a clause called a jurand, certifying where, when, and before whom the affidavit was sworn. Usually, affidavits are sworn before a notary public, who then signs the affidavit and puts an official seal on it. Although the phrase sworn affidavit is often used, it is redundant since an affidavit is by its very nature a sworn document, and because it is sworn, the affiant can be prosecuted for committing the crime of perjury, that is, lying under the oath, if he or she has told falsehoods in the affidavit.
A public company. There is often confusion over the term public company. Now, a public company is actually a reference to a legal term which is a public limited company, and this is a company that is permitted to offer its shares to the general public. This could be also by way of the stock exchange, although companies which are on a stock exchange are often referred to as either listed or quoted companies. A public company should also be distinguished from a private company, also referred to as a private limited company. This is a company which is not permitted to offer its shares to the general public, but both public and private companies operate in what is known as the private sector. A public company should not be confused with what is known as a state-owned company. So a public company is a public limited company, but it's not a state-owned company. A state-owned company is a company which is owned by the government for the benefit of the general public, but the difference there is that it operates in the public sector. Thank you. Alter vires is a Latin phrase which means beyond or outside the power of, and the alter vires doctrine is usually applied in reference to the actions of corporations or directors or government bodies and bodies authority. With regards to corporations, a corporation may be set up for a specific purpose. If a company enters into a contract which is outside the purpose for which the company has been set up, then the company can be said to have entered into an alter vires contract. Directors of a company have certain powers or limitations in their powers. If they should go beyond their powers or exercise their powers in their own way, then we can say that they have carried out alter vires actions, and shareholders may then sue the directors to recover losses for alter vires acts. With regards to governing bodies or public authorities, there may be statutory instruments which determine what these public authorities or bodies are allowed to do, as well as the procedure or process for them to carry out their various actions. Should these public bodies go beyond the powers given to them by statute, or should they not follow the rules in coming to a certain decisions, then the decisions made can be challenged as being alter vires or outside the power of that particular body. Thank you.
Authority Binding authority, ostensible authority. There are two types of authority that will be considered by judges when coming to a judgment in a case. The first type of authority is binding authority, and then we have persuasive authority. There are two sources of binding authority. The ratio decidendi, which is more commonly known as the ratio in British English. Americans refer to the rationale of a case and statutes. The ratio of a case is the principle, the ground, the reason for a decision in a case. And this is what forms a precedent. And precedent then is the ruling which has to be applied in future cases where something comes up to a court which covers similar facts, similar legal issues, and generally a court will be bound by itself. There will be certain exceptions under which a court can overrule one of its own judgments. Generally, it binds itself and also all lower courts. The second source of binding authority is statutes or legislation, so written law. Law that is enacted by the legislative branch of government, that is by legislature. Binding authority is not the only form of authority that will be considered by judges. They can also consider persuasive authority. Persuasive authority, as the name implies, can help convince or persuade, or can help a judge reach a decision, but he is not actually bound to follow those authorities. And these are the most common examples. The ratio, being the ruling, is implied as precedent. Anything else that the judge says in a case that isn't ratio is said in dicta or obiter dicta. More commonly, we talk about what a judge says in dicta, and these are the kinds of things, the other things that a judge says in a judgment. He might consider what the law would have been had the facts been slightly different, for example. Dissenting judgments can also be considered, and a dissenting judgment is a judgment that is given by a judge who does not agree with the majority opinion. And sometimes they say things that could be considered by judges in future cases. And finally, another form of persuasive authority would be other legal writings, especially authoritative legal writings. Maybe an interesting article or a well-written article about a new piece of legislation that's been published in a legal journal.